Trump's indictment is not the slam dunk case liberal media believes it is. There are several realistic lines of defense that Donald Trump's attorneys can use to help their client win his case. The media's pronouncements that Donald Trump is almost certainly guilty of crimes are based on an ignorance of the law and a blinding political bias. As is often the case with capacious fiats mouthed by the featherhead class, the opposite is true. The former president has several viable defenses. Some will be offered in pre-trial motions challenging the 37 charges in a Florida grand jury indictment related to his handling of alleged classified documents. These motions are appealable if denied. Such interlocutory petitions and arguments are laborious and time-consuming. They render special counsel Jack Smith's stated ambition of a speedy trial fanciful, at best. Presidential Records Act. It is another elementary tenet of law that if statutes are in conflict, the more recently implemented statute predominates over the earlier one. Here, the Records Act was passed 61 years after the Espionage Act. This makes it more recent, relevant and operative. Trump's lawyers will argue that the PRA is the governing and controlling law, not the Espionage Act. So, what does that law mean? For more than a decade, it was the considered opinion of the Department of Justice that the PRA conferred a unique right on former presidents to keep whatever presidential records they want, and the government has no authority to seize them. The National Archives agreed. A president has the sole discretion to segregate and dispose of records. Trump's principal defense rests with the Presidential Records Act, PRA. It is not farcical, as former Attorney General William Barr claims. It was a law passed by Congress in 1978 that granted an exclusive right of former presidents to maintain custody and control of presidential papers accrued during their terms in office. Arguably, it includes classified documents. It is a fundamental precept of law that specific statutes prevail over general statutes. The PRA is a specially crafted law that applies to a narrow group of people. That is, presidents. By contrast, the Espionage Act enacted in 1917 is a general statute that applies broadly to all citizens. Hence, the defense will argue that PRA takes precedence over the Espionage Act, which accounts for most of the charges against Trump. Indeed, so convinced was the DOJ of this interpretation that its lawyers defended it in U.S. District Court in Washington, D.C., in 2012. They argued that ex-President Bill Clinton was allowed to maintain custody of whatever he wanted during his 2 terms, including audio tapes with suspected classified information that he stored in his home. The judge, without reservation, agreed. District Judge Amy Berman Jackson ruled that control over presidential records rests squarely in the hands of a former president. She wrote, in relevant part, the National Archives does not have the authority to designate materials as presidential records. It lacks any right, duty, or means to seize control of them. The judge also adopted the very argument made in court by the Justice Department. Seizing the records is an extraordinary request that is unfounded, contrary to the Presidential Records Act's express terms, and contrary to the traditional principles of administrative law.